Yes, we're ready. We're ready to begin because I know everybody's on the tight schedule, so we certainly appreciate it. I'm going to have Jacob Pavillion, we call Jake, our staff here, key staff member. He's going to call the roll.
Good afternoon. 2 points of logistical order. One, there's a microphone in front of every member. When the button's up, that's when you'll be on live audio. I just ask that if you're not speaking, if you can make sure the button is pushed down. That way there's no feedback. As you can tell, we're being broadcast online right now on Capitol TV. And the second point of order would be as far as the face coverings. When you're speaking into the microphone, if it's more comfortable, you can take the covering off. But when you're not speaking, I would just ask that you put it back on. With that, I'll call the roll. Senator Harold Metz. Present. Senator Cynthia Coyne.
Present.
Senator Gordon Rogers. Attorney General Peter Neronha.
Present.
Colonel James Manni.
Here.
Colonel Hugh Clements.
Here.
Michael LEOBoR from the Rhode Island Human Rights Commission.
Here.
James Vincent from the Providence branch of the NAACP.
Here.
Anthony Capezza from the Rhode Island AFL-CIO.
Here.
Marcelo Betancourt from the Latino Policy Institute.
Here.
Jose Batista from the Providence External Review Board. Oh, great. Reverend Howard M. Jenkins, Jr.
Here.
Reverend Chantel N. Washington. Present. Senator Metz, you have 12 members present, 1 member absent. You have a quorum.
Yeah, if you'll move forward with the...
Item 2 on the agenda is appointment of a chairperson. I have a letter from the Senate President that I'll read into the record. Dear Senator Metz, it is my honor to inform you that pursuant to Senate Resolution 2867, I have appointed you to chair the Special Legislative Task Force to review and provide recommendations on policies pertaining to the Rhode Island Law Enforcement Officers' Bill of Rights. This commission is expected to report findings and recommendations by February 9th, 2021. I look forward to working with you and the other members of this commission on achieving those recommendations. Sincerely, Dominick J. Ruggerio, President of the Senate.
Yes, thank you, Jacob. I want to thank the Senate, certainly the Senate leadership, for their confidence in having me serve as chair. I do not take this lightly because it's such an important issue, and I want to thank all the commission members for their participation, and a special thanks to many others who contacted me wanting to be on the commission. So we want you to know that your input is welcome. And I also want to thank the prayer warriors that I have praying now as we deliberate. Our goal is to bring proper balance to the system as it relates to protecting our citizens and the reputation of good officers, but not hiding and protecting wrongdoers. And as we give our presentation from 1995, as Jake gives our presentation, more details will be presented. It is extremely important to get stakeholders at the table together and listen to each other, find common ground, rise above the tensions and divisions of these times, examine and follow up on past and future recommendations, and promote healing. For those who question the process and motives of study commissions, let me remind you of the Police Community Relations Act that no one thought was going to pass, and it was from Senator Rhoda Perry, and it fell apart as she was retiring, and she asked me to follow through and to carry her efforts across the finish line. And we got law enforcement and the community to work together to find common ground, and that bill was passed. So we need to continue the collaboration between the stakeholders, and because
Dominick J. Ruggerio, President of the Senate.
Michael LEOBoR, Executive Director of the State Commission for Human Rights.
Reverend Howard Jenkins, President of the Ministers Alliance of Rhode Island.
Tony Capezza, representing the AFL-CIO.
Senator Cynthia Coyne, I represent District 32, Barrington, Bristol, East Providence.
Good afternoon, everybody. Jose Batista on behalf of the Providence External Review Authority, the state's only civilian oversight board.
Good afternoon, everybody. I'm Jim Vincent. I'm the president of the NAACP Providence branch.
Harold Metz, Senate District 6, and I'm honored to serve as the chair of the commission.
Marcela Betancourt, Executive Director of the Latino Policy Institute.
Reverend Chantel Washington for the Rhode Island State Council of Churches.
Good afternoon, Hugh Clements, Chief with the Providence Police Department.
James Manni, Superintendent, Rhode Island State Police.
Peter Neronha, Attorney General.
Yes, thank you. Thank you all again for your participation. At this time, it's good that we have a legislative review of the Law Enforcement Bill of Rights. We also have some information that Jake's going to present from what took place in 1995. And with that, I'm going to turn it over to Jacob Pavillion, our staff member here, to give us the presentation. Jay?
Sure. Thank you, Mr. Chairman. On the screen behind me, you'll see a PowerPoint presentation that, if it isn't in the packet that you received, it will be distributed. The intent of this presentation is to provide a brief overview of the legislative history of the Law Enforcement Officer Bill of Rights, as well as quickly recapture some of the recommendations that were made pursuant to a House and Senate Study Commission in 1995. And following this presentation, we will be hearing from a representative from the National Conference of State Legislatures regarding recent national trends related to Law Enforcement Officer Bills of Rights, as well as policing trends over the last 5 years and directions and policies that state legislatures have put in place. So with that, I'll begin. We all know why we're here today. This is a 13-member commission appointed pursuant to a Senate resolution. The deadline for a report is February 9th, 2021. However, the intent of this commission is to develop not only recommendations, but hopefully arrive at draft legislation that can be presented and introduced in the Senate. As you'll find attached in the package of materials is a report from 1995 that I will discuss in broad detail, whereby a commission arrived at some consensus recommendations that was made up of House and Senate members as well as community stakeholders. And as you'll see in the appendix of that report, there was draft legislation that was arrived at. Not only is this group tasked with making recommendations and improvements to the Law Enforcement Officers' Bill of Rights, they've also been asked to make several other considerations and measures to increase accountability, diversity in law enforcement agencies, policies to enhance police and community relations, and training for greater cultural understanding. All of those are found in the Senate resolution that established this task force. A brief legislative history of Law Enforcement Officers' Bill of Rights. Beginning in the early 1970s, legislation was introduced in the United States House of Representatives to codify certain employment protections for officers at the national level. While this legislation has never been enacted at the national level, several states began introducing statutory and legislative acts based upon this national model. In 1974, Maryland and Florida. Oh, yeah. Sorry, Mr. Batiste. This is my first time. Let's see.
Jake, is this material, has this been passed out? Hard copy?
I don't know if it's been passed out, but I'll make sure everyone has a copy. And all the materials will be posted online. following the hearing. So in 1974, Maryland and Florida became the first two states to pass this statutory protection for law enforcement officers. In 1976, Rhode Island became the third state. It was largely modeled after the previous two states in terms of a model act. And over the course of the next 15 years, about a dozen states in total put in place this statutory protection for law enforcement officers. In 1995, approximately 20 years after the statute was enacted for the first time, a panel was commissioned by House and Senate leaders to review the policies and procedures in place. On the left-hand side of the screen, you'll see and I'll read through them since apparently no one has a copy, so I'll make sure to read through each of them. And I'll also detail the graph on the right-hand side. They arrived at 7 recommendations. 1, to establish maximum time limits for the selection of panel members, commencement, conduct, and conclusion of hearings. At the time, there was considerable thought put into this, putting into place certain timelines and regulations for the appointment of panel members, as well as respondents' response, because it was not an efficient process. Changed the existing appeal procedure to equalize the rights of agency and both officer. All of this is included in the legislation in the packet. Change the laws related to secrecy, these are their words from the Commission, to allow for release of information to the public. Provide procedures and clarification as to law enforcement agency's right to suspend an officer. Allow for the discharge of an officer convicted of a felony who pleads guilty or no contest to a felony charge. The elimination of the 2-day summary punishment from the Law Enforcement Officer Bill of Rights and subject it to existing contractual agreements. And finally, the composition of a hearing panel to establish neutral members on the panel to serve as chairperson, including a process for the presiding justice of Superior Court to select a panel member from a pre-submitted list that can include law enforcement retirees. At this point, I realize I skipped over kind of the guidepost which exists in state statute where the Law Enforcement Officer's Bill of Rights is triggered, so to speak. The provisions of the Law Enforcement Officer Bill of Rights take effect when an officer is under investigation or subjected to interrogation by a law enforcement agency for a non-criminal matter which could lead to disciplinary action, demotion, or dismissal. An important point or graphic from this 1995 report is a survey that was sent out to law enforcement agencies throughout the state of Rhode Island, both state police and local law enforcement agencies, whereby the Commission requested several pieces of information to determine the breadth and depth of Law Enforcement Officer Bill of Rights actions and proceedings. What they found, and they did a 3-year look back, they found it a helpful tool in trying to understand the scope of what they were affecting. What they found at the time over a 3-year look back was that there were 555 total discipline cases, including reprimands, 512 that did not result in hearing under the provisions of the Bill of Rights for the last 3 years. 33 was a number of discipline cases that resulted in hearings on the provision of the Bill of Rights. Of those 33, 18 resulted in findings of guilt by the hearing panel, 7 resulted in findings of not guilty, and 6 were dismissed. At this point, before we hear about national trends in policing and amendments to the Law Enforcement Officers' Bills of Rights as they are constituted in other states, it may help to turn it back over to you, Mr. Chairman, as far as the 4 different areas of focus based on recent discussion, both in the media and before the Senate and House of Representatives here in Rhode Island. One of those being the composition of the hearing panel, which currently is 3 individuals. 2, the summary discipline period and whether that should be extended beyond 2 days without pay. A prohibition on public statements by the law enforcement agency once Law Enforcement Officer Bill of Rights proceedings have commenced. Whether we want to look at streamlining procedures while protecting the procedural due process rights of the officer under investigation. And as we will hear from NCSL in just a minute, whether there should be consideration for enhanced data gathering, transparency, and oversight of these proceedings at a regular interval, such as annually or biannually.
You covered it well, but just do me a favor, as you do the presentation, point to it from the material that you had distributed. That way, people will be able to better. They'll be
And everyone should have a copy of the forthcoming presentation from NCSL in front of them. It's the one that has 4 slides on the first page. Just a moment, Mr. Chairman, just trying to figure out how to move on to the next presentation.
And again, some of the items that we're considering is the composition of the hearing panel, to extend the summary suspension period beyond the 2 days, 3, prohibition on public statements, and the 4th thing is streamlining procedures while protecting procedural due process. So these are some of the things that are under consideration as we go through this process.
Jake?
We can hear you in Rhode Island.
Okay, that's good. I can't hear the chair, but I can hear everyone else, so I just wanted to make sure. So can you see my slides and can you hear me?
Everyone has a copy of the presentation, and they're also being broadcast on Capitol TV and the televisions behind us.
Okay, excellent. So first, Mr. Chair, members of the task force, thank you for inviting me to participate in today's meeting. My name is Amber Widgery, and I am the program principal with NCSL's Criminal Justice Program that covers policing issues. On this slide, just a brief overview of NCSL and who we are. We are the bipartisan professional organization for all 7,383 state lawmakers, and also the more than 30,000 state legislative staff. We have offices headquartered in Denver, Colorado, and also Washington, D.C. I'm going to start today with some broad state trends from both the last 6 weeks and also the last roughly 6 years. I think some of this will be helpful. The Rhode Island Law Enforcement Officer Bill of Rights is somewhat broader than the similar provisions in other states. So some of what I cover in this initial trends portion is going to relate to some of the Rhode Island provisions that fall under the Law Enforcement Officer's Bill of Rights. But then at the end, I'll also talk specifically about the sort of state of the states and the content of other states' Law Enforcement Officer Bill of Rights and some of the recent trends specifically affecting those provisions. So first, I'd like to point out that NCSL recently launched a new legislative responses for policing database. And this database contains information on bills that have been introduced or amended in state legislatures since May 25th, 2020. The status of the bills in the database is updated daily, and legislation is added to the database at about a weekly intervals at this point. You can search this database for what's happening in other states by keyword, state, author, bill number, bill status, or by topic. The topics that you see on this slide are actually hand curated and sorted by NCSL staff, and on the webpage that's linked on the slide, you'll find definitions of those topics so that you can get a better idea of some of what those topics contain, because I realize the titles are somewhat broad. So on to what states have been doing. I'll start first with the last 6 weeks. As of last night, 28 states and Washington, D.C. had introduced 395 new bills. 37 of those have now been enacted, and 5 are still awaiting executive action, with an additional 232 pieces of legislation that are still pending. Of the bills that I mentioned on the last slide, those 37 enacted represent actions in 16 states and Washington, D.C. And on this slide, you'll see a broad overview of some of the topics that have been addressed by those enactments, but in the following slides, I'll provide a little bit more detail and a few state examples where you can reference later what some of those actions have been. A fair number of states have proposed legislation that would require data tracking of various aspects of police-community interactions, and related states have also created study committees, not unlike this body, to review existing data and information and make recommendations related to policing policy going forward. Like Rhode Island, Louisiana also created a new task force to study specific areas of policing issues. And then Oregon and Georgia took a slightly different approach, creating new committees to oversee police policy work. Under the data collection portion of this slide, the new Colorado law requires reporting and public dissemination via a public database of broad information on use of force incident data, and also demographic information related to police stops. New York has also recently required new data tracking and reporting, but that scope of the legislation is limited only to arrest-related deaths. And then finally, Vermont had a new law just in the last 2 weeks that requires or conditions receipt of state grant funding on compliance with previously existing data reporting requirements. There's also been a focus on use of force. This has included changing statutory standards that are codified for use of physical force and also use of deadly force. State laws have restricted specific kinds of force, including chokeholds, use of less lethal means of force, like chemical weapons or projectiles. And then all 7 states that have enactments in the area of use of force, you'll see have also addressed chokeholds or other specific restraint maneuvers. Sometimes those laws are blanket prohibitions, and in other instances, those laws are simply restricting the use to circumstances when deadly force would otherwise be authorized. The Colorado law you saw on that first slide is probably the broadest, but like I said, 7 states since May have addressed changing their use of force policies. Related to that, states have also addressed use of force by creating affirmative statutory duties to intervene in situations of misconduct or excessive force, and also affirmative duties to report incidents of excessive force. At least 2 states have also created a duty to provide medical assistance or aid for individuals in an officer's custody, whether that's under arrest or otherwise in their custody. And then some of these provisions have also addressed officer liability if they fail to intervene or otherwise violate an individual's civil rights. And the Colorado law is also the broadest here, creating personal liability of up to $25,000 or 5% of any judgment. And then finally, related to use of force, states have also continued working to create more transparent investigations of use of force and have also expanded independent prosecution mechanisms. Iowa and New York recently authorized state-level agencies or officials like the Attorney General to investigate, and also enabled them to prosecute officer-involved offenses. In Iowa, the Attorney General can actually intervene and take action even if intervention is not requested by local officials in the state. Moving on to sort of the next big topic, a lot of states have also provided stronger guidance or required new training, both annual training and initial training tied to officer certification in the state. Examples from the last 6 weeks are listed here. Some of these training requirements address training on new use of force provisions, de-escalation training, restricting the types of training related to certain kinds of use of force, and then also the Iowa law specifically required prevention of bias training. Recent enactments have also provided guidance as to what types of serious misconduct would require that an officer be decertified or suspended. These new enactments provide guidance on when decertification is mandatory under state law or within the discretion of a state regulatory agency, such as in some states this is the Post Board or the Police Officer Standards and Training Board. 5 states have enacted new laws that address this topic specifically. Some of those laws provide broader access to certification information, and both the Colorado and Oregon laws require new statewide publicly available decertification databases. Oregon has actually already launched that database, but Colorado has a statutory timeline that provides for additional time for implementation. Recent state laws have also addressed the use of body-worn cameras for officers. 4 states, Colorado, New Mexico, New York, and most recently Vermont, have now required broad statewide adoption of this technology for at least some officers on a statewide basis. These laws also provide regulation and guidance on the use of these devices and also data and other best practices policies related to the footage produced by body cameras. Finally, I want to highlight that our new database also tracks executive orders, which has been important in some states. 3 other statewide bodies were created by executive order to study policing. The Pennsylvania order established a new Citizens Commission on Policing. And I should also highlight the Connecticut order in particular, because unlike some of the other executive orders, it made substantive changes related to use of force policy, community engagement, demilitarization of departments, and also body-worn cameras. Up to this point, I've been talking about legislative enactments from the past 6 weeks, and now I want to turn my attention to a little bit of the longer timeline with trends going back to 2014. Collectively, legislation in both the last 6 years and the last 6 weeks have expanded state-level involvement in and oversight of policing issues. I've highlighted a few of those big picture trends on this slide, but I want to highlight a few of the more detailed policies in the coming slides. And I list everything on these coming slides out just by the number of states. It's a by the numbers overview, but I'd be happy to provide Jake and members with additional information as to which states compose each of these numbers. So first, all 50 states have a citation in lieu of arrest policy. These laws provide a broad framework for officers to limit the use of jails in the booking process. Use of citation in lieu of arrest is also generally controlled by department level policy. We saw a lot of changes related to this during the initial stages of COVID-19 pandemic, with departments really broadening the use of these policies to match the state level framework, which tends to be broad in most states. 27 states and DC have authorized or required training for law enforcement officers to improve responses to individuals with mental health, substance use, or other behavioral health disorders, recognizing that many officers don't receive adequate training for those encounters in their initial training. 21 states require data collection of demographic information for motor vehicle or other stops. 15 states have created procedures to improve transparency and integrity of investigations into officer-involved deaths or instances of excessive force. This has included creating frameworks for independent state-level investigation, like the Attorney General model I mentioned in Iowa earlier from the last 6 weeks. We're also creating more transparent and independent local or regional investigative models that involve officers or investigators outside of the local department in the process. Legislation has also required public disclosure of the investigation results and related reporting requirements. Sometimes those requirements require end-of-year reporting back to the governor or to the legislature or to another statewide oversight body. 15 states require reporting or data collection on use of force incidents, recognizing that data on a national level on this topic is currently limited. 13 states and Washington, D.C. have appropriated funds for police departments to support the use of body-worn cameras. 12 states have required training relating to cultural or racial diversity or differences, training on the prohibition of racial profiling practices, and training to raise awareness of personal bias, and also training for supervisors to detect and then effectively respond to bias-based behavior. 12 states have also required or created guidelines for establishing crisis intervention teams. And this is something we've seen a lot more of in the past couple of years, but also recent interest in creating alternative policing models. 11 states have laws supporting the duty to intervene. Creating an affirmative duty or an affirmative statutory duty at the state level is something that's really new within the last 6 weeks, but other state laws have addressed the federal constitutional duty to intervene and have addressed related liability. 11 states and Washington, D.C. have now restricted or prohibited NIC restraints, and also a couple of states have addressed training on the use of NIC restraints. 10 states now require independent investigation of police-involved incidents by a state-level agency, the Attorney General, or some other source outside of the immediate department. And 8 states now require that at least some law enforcement officers utilize body-worn cameras on a statewide basis. So that wraps up my overview of sort of trends from the last 6 weeks, the last 6 years, and now I want to turn my attention specifically to law enforcement officers' Bill of Rights. 19 states have a statutory provision that could be considered a law enforcement officer Bill of Rights using the broadest interpretation of the ways that I could define these laws. Some of these provisions are limited in scope of the topics that they address and the applicability to officers and departments, but at the core, they all address the rights of officers during investigations into potential misconduct or officer-involved incidents. The vast majority of these laws were enacted initially, as Jake mentioned, in the 70s and 80s. Since that time, about half of these laws have been, well, let me back up. About half of these laws have been amended in the last 6-year period specifically that I also just covered. But I should note that there hasn't been a trend of sweeping changes to law enforcement officer bills of rights. Many haven't been amended since they were first enacted. And some of the enactments that have affected some of the provisions that have been amended in the last 6 years were technical in nature and not substantive. To give an example of this, some of the revisions have addressed, the renaming of state agencies or definitional changes related to who qualifies as a law enforcement officer. We've seen some changes to the application of who the laws apply to. This has included broadening the scope. For example, a 2018 Delaware law extended the applicability of the Law Enforcement Officer Bill of Rights to probation and parole officers. There have also been a handful of substantive changes in recent years, and I'll take a minute to address a few of those examples. Nevada Senate Bill 242 from 2019 required that law enforcement officers receive back pay if they were suspended and then later cleared of any misconduct. That same bill also provided an option for an officer to stop an interview at any point if it becomes apparent that it could result in punitive action, and the peace officer at that time requests representation. The law also expanded an officer's access to physical evidence and other information related to the investigation that had to be provided to them prior to an interview. Florida House Bill 573 from this year, 2020, earlier in the year during the regular session, provides for confidentiality of peer support communications between first responders, which includes law enforcement officers. There are a few limited exceptions that are related to the potential for or existing criminal conduct. The new law also covers part-time officers, expanding the scope of the provision, and it also provides department or law enforcement agency heads with the ability to request a sworn or certified investigator from outside the department if a conflict is identified within the agency conducting the investigation. The outside investigation is authorized notwithstanding any other provisions of the Law Enforcement Officer Bill of Rights or any collective bargaining agreements that might be in place. A 2018 Arizona law authorized note-taking during interviews, and then a subsequent 2019 law authorized officers to record those interviews, and also expanded the information to which officers had access to include initial complaints, any audio and video recordings, photos, witness statements, and other evidence. A 2017 Tennessee law required that investigation records of officer-involved shootings be made public after their completion. And so that sort of gives a summary of some of the real substantive enactments that have affected law enforcement officer Bill of Rights in the last 6 years. But now I want to provide a little bit more background on sort of the 19 states as a whole that I've identified on the map on the slide. So which officers a law enforcement officer Bill of Rights applies to varies by state. State laws can apply only to rank and file officers. In some instances, they apply to rank and file officers and supervisors or chiefs, or they can be extended to cover other related professions such as corrections officers, probation and parole officers, or even in like 2 states, firefighters as well. Most law enforcement officer Bill of Rights don't specify the type of conduct, whether that's criminal, disciplinary, or other, to which they apply. However, there are a few states that are slightly more specific. The Illinois law specifically does not apply when an officer is being investigated for alleged criminal conduct. Conversely, the law in Wisconsin specifically applies to all investigations that could lead to criminal or any kind of disciplinary action. Additionally, there are differences as to what types of investigations trigger these provisions. In some states like Nevada, a law enforcement officer Bill of Rights would only apply to a formal investigation. Language in other states is somewhat more vague and may have a broader application in practice. The Delaware law, for example, applies the law enforcement officer Bill of Rights whenever a law enforcement officer is under investigation or is subject to questioning for any reason which could lead to disciplinary action, demotion, or dismissal. Most of these provisions also require that an officer be notified of an investigation. What is included in that notice, however, varies pretty greatly by state, but the following are what can be included. General provisions include date, time, place of any hearing or interview. Some states also include the names and ranks of officers who are in charge of investigation. Sometimes this includes the names and the badge number of individuals who will be present during any interview, the nature and circumstances of the investigation, the names of complainants, copies of any sworn statements, witness statements, or specific outlines of facts, a copy of the complaint, a statement of the rules that apply, and also copies of the rules that apply to a particular investigation, and also notice of any discipline or penalties, and in some instances, any other evidence, and then states sort of have a varying list of evidence that could be included in sort of that catch-all. State law enforcement officer Bill of Rights laws also generally provide for periods of time for officers to secure representation before investigations or interviews can begin. Some states actually specify a time frame, while others provide a more general, reasonable period of time guidance. Time frames in statute range from 48 hours to 30 days, depending on the state and circumstances. Most laws also authorize representatives that include lawyers, union representatives, or other persons to be present during an interview. State laws also control the structure of any investigations as well, providing limits on the place, time, circumstances, duration of questioning, and or the number of investigators that may be involved in questioning at any time. In addition to regulating officer investigation, a handful of law enforcement officer bills of rights, including the Rhode Island bill, also address hearings related to officer discipline. States that have laws that include hearings address the timing of the hearing, the composition of the hearing board, and required notice of the hearing, the scope of the cases that require a hearing, and also hearing procedures in some instances. If the hearing authority is specified in law, which is not always the case, the panel generally consists of other law enforcement officers. This is the case in at least 6 states: Alabama, Delaware, Maryland, Rhode Island, Virginia, and West Virginia. The Alabama law also offers sort of an alternate model and authorizes that the hearing can be conducted by a body with the authority to suspend or terminate a law enforcement officer, and then the statute specifically cites a municipal governing body as an example. Other statutes are less explicit, but imply a similar hearing procedure when they are addressed in statute. To provide a couple examples of some of these sort of alternative statutes, Arizona law references hearings conducted by a hearing officer or an administrative law judge. Tennessee vaguely references a hearing panel in law, and Kentucky also has a general reference to the hearing authority. Case law in some states has also had an impact. California law, for example, requires a hearing but doesn't specify any process for implementation or procedures surrounding the hearings. So the courts have had to further clarify the statutory language. And case law in California has required that hearings be conducted by a neutral fact finder, and that hearings at the request of the officer be open to the public in accordance with due process requirements. States that provide for hearings also generally provide for some sort of appeal mechanism as well. Related, state law enforcement officer Bill of Rights have also specifically limited civilian participation on complaint review boards or in the investigation process. This is done in sort of a number of ways. The regulation of the complaint process, including the form of civilian complaints and complainants' participation in the process, is addressed specifically in a number of ways. States have also placed limitations on officer discipline after a set amount of time is passed. These provisions are akin to statutes of limitations. And with that, I'm going to leave it there. This was sort of a broad overview and a lot of information, and I just wanted to provide an opportunity for questions at this time.
Yes, we've been presented with a wealth of information from Jacob, certainly on the history of the Rhode Island law. So we have a big package on that, and Amber gave us the national trends. It may take us a while to digest it, but if there's any questions that anyone has at this point, you can ask Amber now, please. And if not, as we digest this material, if you do, as you digest the material, if you have questions, forward them to Jake, and you have you have his information, and he'll be either he'll do it himself or he'll contact the NCSL to get you the information or to answer your questions. But Amber, we certainly appreciate that very thorough presentation. Any questions? Yes, ma'am.
I did have one question. Someone could explain to me how the statute of limitations works with the Rhode Island. So that we can kind of discussion is the one of the Senate Chapter 1 and the so even there in the state of Rhode Island. And the question that I have is that the statute of limitations in terms of the officers when that time they kept waiting for it to run out, so that these officers did not be sued, and yet they were able to go back to work. One was promoted as sergeant. So just moving forward, God forbid that things will even happen. Well, what happens in the terms of the statute of limitations? Is there a certain amount of time at which that a civilian can proceed forward? That's just my question.
Well, we'll find that out for you, but this particular meeting, it was the first time the commission got together, and some people work in the legal profession, others of us are from the community, and we wanted to be presented. This meeting here was to be presented what the actual law is and to find out what they're doing nationally. And then once we boil that all down and look at what needs to be done in Rhode Island, then we can begin to answer the questions that because we'll be open up to the community at some point. But this particular meeting today was just for the commission members to get ourselves oriented. But we'll keep your question about the statute of limitations in mind as we move forward.
Senator, Mr. Chairman, with that in mind, maybe we should discuss logistically planning the next few meetings and what we hope to cover individually at each one of those meetings.
Yes, if we could do that. I mean, we talked about several things. We just heard the question about the statute of limitations. Certainly, the composition of the hearing panel, there's something certainly that we need to consider. Summary discipline period beyond the 2 days. Prohibition on the public statements. Streamlining procedures while protecting procedural due process, and enhanced data gathering and transparency transparency, and oversight, so that we can deal with different things about the statute of limitations and these various things. And so at this time, I'd like to open it up for discussion to my colleagues on the commission about what they hope to learn and who they hope to learn it from. And so with that, and also, I want to move as expeditiously as possible. Is Wednesday a good day? Because I know Jake was trying to get everybody's schedule together. Today worked out to be a pretty good time. Is Wednesday at 1:30 a good time for most people? Yes. Do we have? I think so. Jake, we'll keep that. We'll keep that in mind. Yeah. Yes, Mr. Vincent.
Okay, Jim Vincent, NAACP. Very good presentation by the National Conference of State Legislatures. And I'm just curious in terms of the 19 states. I mean, they said 10 states had this, 5 states had that. I want to make sure I know where, which states are which and where Rhode Island is or is not, so that I can do my analysis in terms of where we fall in that continuum. Because, from what I heard, we have the most pro-police Bill of Rights of any Bill of Rights in the nation. So I want to be able to analyze that because that's what I've heard, and it must be based on the data that is what was presented this morning or this afternoon.
Okay. Yes.
Just go ahead.
Reverend Jenkins, question for you. Your presentation, your opening presentation was very good. You said it's online. How can I get access to that?
So all commission documents will be made available online, hopefully prior to each hearing. Now, they'll all be online this afternoon with regards to what was presented today. Mr. Chairman, if I may, with respect to Mr. Vincent's comment as far as how Rhode Island statute fits in with the other 19 states. We heard from the National Conference of State Legislatures as far as who it applies to. Well, Rhode Island, it's permanently employed police officers, and it goes on to delineate a few other state agencies, such as the Rhode Island Airport Corporation. What I think would be an appropriate next step prior to next meeting is the different components of our law enforcement officer Bill of Rights I can put into legislative context with the other states to see how our scope is different from their scope possibly, as well as composition of hearing panels and disciplinary proceedings and things of that nature, as well as privileged information.
Would that be all right for you?
Sure, yeah.
And Reverend Jenkins, make sure that we have the information for Reverend Jenkins about how to access it online.
And everyone will be leaving with a copy of the
and I think perhaps we need at least one meeting for attorneys that traditionally represent the opposing parties to discuss issues and nuanced issues of procedure, process, and fairness that we're trying to understand and develop recommendations on, because I think we need some clarity on that. So anyone have any thoughts along those lines? Anyone have any thoughts along? And at least one meeting of interested state agencies and departments and law enforcement agencies to weigh in on changes that they would like to see.
That makes sense.
And certainly at least one meeting for the community groups, because I've had any number of people call me. Dare just called me about an hour ago. Several other people. The bias, Rhode Island Commission on Bias.
Commission on Bias.
The Commission on Bias. There's been several people that have contacted me that want to give input on this issue. So we're certainly going to have something for the community so that we can hear their voice.
And Senator, I'd also like to add the faith communities to that group as well.
Yes, okay. So community and the faith community. And then if we need, as things develop and we see another area that we need to look at, we can schedule, have future meetings. So we're not limited to that, but we have to get started at somewhere. And so certainly I'm not a lawyer. I've been reading this stuff, but I need a little more time to digest it myself. And so it'll be very helpful, that next presentation, Jay. Is there any further? Yes. Yes.
You gotta push it hard.
Did the green light come on?
One area we might want to look at also is inviting the Police Chiefs Association, especially when we're talking about the training that we just went over. They would know best.
Okay, the Police Chiefs Association? Okay.
Conducted by their departments. The other suggestion I would make, I think might be helpful, would be, as they did in 1995, if we asked the municipalities to submit, in 95 they went back 3 years of all the discipline that they issued out, whether they went to a Bill of Rights, they were settled, or whatever the outcome was. So I think that would be helpful for everybody on the panel to know what happened and how it was resolved. So,
yeah, that's good.
Yeah, thank you. Thank you. Yes, Jose?
If I may, thank you again for the opportunity to serve on this very vital board and opportunity to review this very important law at a very important time in history. I would just make two recommendations to the board, to my colleagues. Number one, as we're thinking about this Bill of Rights, as this statute, we're ultimately thinking about public employees. Right? Police officers are public employees, and to that end, I think part of our study, it would be wise for us to study how our municipalities treat other public employees, such as teachers, firefighters, city workers. My sense is that there's a significant disparity in between the way we treat the groups that I mentioned and police officers, so that would be one. I know that this board is focused on the Law Enforcement Officers Bill of Rights, but it would be wise for us to study the alternatives. I don't think there's a Bill of Rights for any of the other groups, and so that would be helpful to us, it'd be instructive to us. And the second thing that I would propose to my colleagues and to this board, on behalf of my pair of members, it seems that we are having this conversation, including the presentation we received, seems rooted in the presumption that we should keep the Bill of Rights and make changes to it. I would like to submit to the board to consider maybe we need to work the opposite way around and decide to immediately repeal the entirety of the Bill of Rights and spend the rest of our time figuring out how to fill in the gaps. I think that the root of our work would probably be better served in the second option. So I just wanted to propose both of those measures to my colleagues here on the board, and to thank you all for the opportunity to work with you on this very important issue.
Thank you. Any further discussion? Any further discussion? Jake, I'm going to turn it back over to you at this point.
So bearing in mind Mr. Capeza's suggestion, would it also make sense if I distribute a draft survey to law enforcement agencies? Well, I would distribute it to the commission members before the next meeting for you to review, with the idea that it would be sent out at some point this summer to understand how this protection and hearing process has been used, and in what number over the last 3 to 5 years. If you look at the 1995 report, they had a 3-year look back. You'll see that a vast majority of disciplinary actions that are taken never go to a law enforcement officer Bill of Rights hearing, but I'm happy to prepare a similar survey for everyone to comment on, obviously before it gets sent out, but before the next meeting, and we can review it at the next meeting.
My only comment would be, if you do a 3 or 5 year, can we look at the trends one way or the other? So could you break it out so that we can see?
So have the ability to look at individual years as well?
Individual years so that you can see if there's trends up or down in any particular category. If that's possible, maybe it's not, but 3 year or 5 year, maybe a comparison at a minimum.
Any further discussion? Any further discussion? If not, I want to thank everyone for their participation. And we just have a motion to adjourn.
I make that motion. So moved.
Properly moved, a second. All in favor?
Aye.
Any opposed? Okay, thank you all very much. Appreciate it.